Be seated, please. Ladies and gentlemen, the jury, when you enter the jury box, you find a photocopy of the court's charge. I'm going to present that charge to you in its entirety in just a moment. Those are your copies to use as I read from the original, and those are your copies to use during your deliberations. When you're prepared to return your verdict, be sure you do it on this original. The main difference is that mine's got the clerk's file stamp on the front, so be sure your presiding juror has this one. Once the charge is presented, we'll hear initial arguments from the state and the defense. We'll take about a 15-minute break, and then we'll conclude the arguments, and you'll be allowed to deliberate your verdict. Ladies and gentlemen of the jury, the defendant, Kody Lott, stands charged by indictment with the felony offenses of murder and aggravated assault, alleged to have been committed in Wichita County, Texas, on or about September 2nd, 2016. To this charge, the defendant is pled not guilty. You are instructed that the law applicable to this case is as follows. 1. A person commits murder if he intentionally or knowingly causes the death of an individual. Individual means a human being who has been born and is alive. Bodily injury means physical pain, illness, or any impairment of physical condition. Act means a bodily movement, whether voluntary or involuntary, and includes speech. Murder and aggravated assault are felony offenses. A person commits the offense of aggravated assault if he intentionally, knowingly, or recklessly causes bodily injury to another and uses or exhibits a deadly weapon during the commission of the assault. Deadly weapon means a firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. 2. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 3. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. 4. In a criminal case, the law permits the defendant to testify in his own behalf, but the same law provides that his failure to testify shall not be considered as a circumstance against him. You will, therefore, not consider the failure of a defendant to testify as a circumstance against him, and you will not, in your retirement, to consider your verdict, allude to, comment on, or in any manner refer to the fact that the defendant has not testified. 5. You may not consider in your deliberation the potential consequences to the defendant of a verdict of not guilty by reason of insanity. 6. Voluntary intoxication does not constitute a defense to the commission of a crime. Intoxication means the disturbance of mental or physical capacity resulting from the introduction of any substance into the body. 7. You are instructed that unless you believe from the evidence beyond a reasonable doubt that the alleged confession or statement given to Officer Killingsworth introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you shall not consider such alleged statement or confession for any purpose, nor any evidence obtained as a result thereof. 8. You are further instructed, as part of the law in this case, the indictment against the defendant is not evidence of the case. The true and sole use of the indictment is to charge the offense and to inform the defendant of the offense alleged. The reading of the indictment to the jury and the statement of the case of the state against the defendant cannot be considered as a fact or circumstance against the defendant in your deliberations. In deliberating on the cause, you are not to refer to or discuss any matter or issue not in evidence before you. In determining the guilt or innocence of the defendant, you shall not discuss or consider punishment, if any, which may be assessed against the defendant in the event the defendant is found guilty beyond a reasonable doubt. You are charged that it is only from the witness stand that the jury is permitted to receive evidence regarding the case or any witness therein. No juror is permitted to communicate to any other juror anything he or she may have heard regarding the case or any witness therein from any source other than the witness stand. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you're bound to receive the law from the court, which is herein given you, and be governed thereby. Do not let bias, prejudice, sympathy, resentment, or any such emotion play any part in your deliberations. 9. Defendants are presumed to be sane, and the state carries no burden to prove sanity. It is an affirmative defense to prosecution that at the time of the conduct charged, the defendant, as a result of severe mental disease or defect, did not know that his conduct was wrong. The term mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial behavior conduct. The severe mental disease or defect must have existed at the very time or times inquired about, that is, at the very time of the alleged commission of the offense. The burden of proof is on the defendant to prove the affirmative defense of insanity by a preponderance of the evidence. The term preponderance of the evidence means the greater weight and degree of the credible evidence in the case. 10. Count 1. Now, bearing in mind the foregoing instructions, if you believe from the evidence beyond a reasonable doubt that the defendant, Kody Lott, on or about September 2, 2016, in the county of Wichita and state of Texas, intentionally or knowingly caused the death of Lauren Landavazo, an individual, by shooting Lauren Landavazo about the body and or head, then you will find the defendant guilty of the offense of murder, and so say by your verdict. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant. 11. Count 2. Now, bearing in mind the foregoing instructions, if you believe from the evidence beyond a reasonable doubt that the defendant, Kody Lott, on or about September 2, 2016, in the county of Wichita and state of Texas, intentionally, knowingly, or recklessly caused bodily injury to Michaela Smith by shooting the body of said Michaela Smith with a firearm, and the defendant did then and there use or exhibit a deadly weapon to wit a firearm during the commission of said assault, then you will find the defendant guilty of the offense of aggravated assault, so say by your verdict. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant. 12. Count 1. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Kody Lott, committed the offense of murder as alleged in the indictment, but you further find by preponderance of the evidence at the time of the conduct charged, the defendant, as a result of severe mental disease or defect, did not know that his conduct was wrong, you will acquit the defendant, say by your verdict, not guilty by reason of insanity. However, if you find from the evidence beyond a reasonable doubt that the defendant, Kody Lott, committed the offense of murder as alleged in the indictment, and you further find the defendant has not proved by preponderance of the evidence that the defendant, as a result of severe mental disease or defect, did not know his conduct was wrong, you will find the defendant guilty of the offense of murder, and so say by your verdict. 13. Count 2. Now, bearing in mind the foregoing instruction, if you find from the evidence beyond a reasonable doubt that the defendant, Kody Lott, committed the offense of aggravated assault as alleged in the indictment, but you further find by preponderance of the evidence that at the time of the conduct charged, the defendant, as a result of severe mental disease or defect, did not know that his conduct was wrong, you will acquit the defendant and say by your verdict, not guilty by reason of insanity. However, if you find from the evidence beyond a reasonable doubt that the defendant, Kody Lott, committed the offense of aggravated assault as alleged in the indictment, And you further find that the defendant has not proved by preponderance of the evidence that the defendant, as a result of severe mental disease and defect, did not know that his conduct was wrong. You will find the defendant guilty of the offense of aggravated assault, and so say by your verdict. 14. In addition, if you find the defendant guilty of a felony offense, you must further find beyond a reasonable doubt whether the defendant used or exhibited a deadly weapon, namely a firearm, during the commission of the offense. Now, bearing in mind the foregoing instructions, if you believe beyond a reasonable doubt that a deadly weapon, namely a firearm, was used or exhibited during the commission of murder as charged in the indictment, then you must make an affirmative finding as to that special issue. But if you have a reasonable doubt that a deadly weapon, namely a firearm, was used or exhibited during the commission of the felony offense, then you must make a negative finding as to that special issue. 15. After the reading of this charge, you shall not be permitted to separate from each other, nor shall you talk with anyone not of your jury. After argument of counsel, you will retire and select one of your members as a presiding juror. It is the presiding juror's duty to preside at your deliberations and to vote with you in arriving at a unanimous verdict. After you have arrived at your verdict, you may use one of the forms for each count attached hereto by having the presiding juror sign his or her name to the particular form that conforms to your verdict. But in no event shall he or she sign more than one of such forms for each count, with the exception of signing the verdict form regarding your deadly weapon finding for each count. After you have retired to consider your verdict, no one has the authority to communicate with you except the officer who has you in charge. You may communicate with this court in writing, signed by your presiding juror, through the officer who has you in charge. Do not attempt to talk to the officer, the attorneys, or the court concerning questions you may have. Signed, Robert P. Brotherton, presiding judge. The following verdict forms are attached for your use. First, verdict of the jury, count 1. We, the jury, find the defendant, Kody Lott, guilty of the offense of murder as alleged in the indictment. Or, verdict of the jury, count 1. We, the jury, find the defendant, Kody Lott, not guilty of the offense of murder as alleged in the indictment. Or, verdict of the jury, count 1. We, the jury, find the defendant, Kody Lott, is not guilty by reason of insanity of the offense of murder. Deadly weapon verdict, count 1. Having found the defendant guilty of murder as charged in the indictment, we, the jury, further find, either find or do not find, that a deadly weapon, namely a firearm, was used or exhibited during the commission of the felony offense. Next, verdict of the jury, count 2. We, the jury, find the defendant, Kody Lott, guilty of the offense of aggravated assault as alleged in the indictment. Or, verdict of the jury, count 2. We, the jury, find the defendant, Kody Lott, not guilty of the offense of aggravated assault as alleged in the indictment. Or, verdict of the jury, count 2. We, the jury, find the defendant, Kody Lott, not guilty by reason of insanity of the offense of aggravated assault. And then the final verdict form, deadly weapon verdict, count 2. Having found the defendant guilty of aggravated assault as charged in the indictment, we, the jury, further find or do not find that a deadly weapon, namely a firearm, was used or exhibited during the commission of the felony offense. Your presiding juror is instructed to sign the applicable jury form that conforms to your verdict as to each count, as to each special finding. With that, the state may proceed.